Judge Shapiro, the parties are here and available when you are.
Good afternoon. Do we have counsel for the state? There he is. Mr. Meyer, are you there?
Yes. Yes, sir. Can you hear me?
Yeah, I can hear you, but I sure can't see you.
Oh, the camera's pointed at the wall. You want me to, let me get the administrative assistant. Hold on a second.
Or you can just stand by the wall if it's not too high. I see it's very high.
I'm short too. You want me to grab him real quick?
Yeah, if you can in a minute. If not, we'll proceed.
Okay.
And Ms. Hartley, you're the court reporter, is that right?
I am, yes.
Right, good afternoon. And we have Ms. Olson from my court staff will be observing the hearing. Good afternoon, Mr. Langschwager. Are you going to finally tell me how to name?
Langschwager, if you come anywhere close and you don't add extra letters, that's all that I ask.
Okay.
I think he's coming.
All right. All right. Well, Mr. Meyer, there's a couple of preliminary things for me to address. So I'm going to begin the hearing, and if the officer comes in to adjust the camera, I'll pause for a moment while he does that, okay?
Okay.
All right. So I'm going to call this case. It is Court of Claims, docket number 23-116, Michael Meyer versus Michigan Department of Corrections. The litigation has been extensive, I suppose, is the right word to say. And I just to make sure that I'm leaving a clear record before I leave this court, I want to just give a little history of the case on the record. So on October 30, 2023, I granted the plaintiff's motion for leave to file a second amended complaint, which he did. On January 2nd, I denied the plaintiff's December 1. I'll pause for a moment.
Oh, he is here.
Okay.
And Your Honor, while Mr. Fager's here, he's actually in possession of the CD, the DVD that was sent in from the 34th Circuit Court.
Well, okay.
And I would just, I noticed in your last, while he's here, if he could just verify that for the record.
Well, if I need him to do so, we're going to have a hearing. If I need him to do so, we'll do it then. But I'm really not up to that yet, and I don't want to prejudice the other side. All right.
Okay.
If you tell me he told me, that'll be okay. All right. We can resume the review of the motions in the case. On January 2nd, I denied plaintiff's December 1, 2023 motion to strike, and I struck man that had been filed on November 13th, 2023. I issued an opinion and order on January 4, 2024, which granted plaintiff's October 13th motion to file supplemental proofs, denied the November 30, 2023 motion to hold counts 2, 3, and 4 in abeyance. I gave plaintiff until February 5 to file an amended complaint to seek a declaratory judgment regarding matters he had sought by motion. And I granted him a temporary restraining order directing the Department of Corrections to maintain the USB drive in question until this hearing today. A decision remains pending as of this moment on defendant's motion for summary disposition on all claims, and plaintiff's motion for possession of the USB drive pending final judgment was held in abeyance pending a ruling on the motion for injunctive relief regarding the USB drive. Now, before we get to the injunctive thing, I want to inform you that I'm granting the defense motion to dismiss all claims regarding the guitar strings, and the deduction of funds from plaintiff's accounts. This includes the claims for mandamus, replevin, and money damages. The motion will be granted on the basis of failure to properly exhaust administrative remedies as required by the Prison Litigation Reform Act, MCL 600.5503 (1), In addition, as to the monetary issue, the DOC has presented unrebutted evidence that the funds were deducted and are being deducted pursuant to proper court orders. I do now want to turn for a moment to the CD because I had something I was going to say about that, but what I'd like to do, Mr. Myers, I want to swear you in, okay? Because you're going to be giving this essentially what is testimony as you give me information. So if you raise your right hand, you solemnly swear to tell the truth, the whole truth, and nothing but the truth in the course of this proceeding.
Yes.
All right, very good. Now, go ahead and tell me what you wanted to tell me about the status of the CD.
I just spoke to Mr. Administrative Assistant Fager, and he indicated to me that he still had possession of the CD and DVD. And I noticed in your January 8th order, you had stated that that the CD or DVD was not accepted for receipt and was sent back to Ogama Circuit Court at plaintiff's expense. But that actually didn't happen. He has possession of it still.
All right, Your Honor, I'd like to object for hearsay. He's telling you what Mr. Fager said.
All right. All right. Mr. Meyer, do you want to ask do you want to call Mr. Fager as a witness here in this regarding that? I'll allow you to do that.
Yes, sir. Could I go grab him real quick?
Can go ahead and poke your head out and ask him to come in.
They're calling him up here right now.
All right.
You're calling him right now, correct?
Well, when he comes in, I'll be happy to allow you to ask him some questions and to have Mr. Langschwager ask questions as well. But let's turn for a moment to the USB, all right? I have a question for you, Mr. Meyer. Am I correct
Yes, sir.
in understanding that the materials on the USB are not items that are part of the lower court record in your criminal trial?
There are some that are and some that are not. Yes, that's correct.
Well, tell me what exhibits, if any, are in there that you do not have access to pursuant to the normal proceedings and court rules where the court has to provide you with any exhibits that are part of the lower court record.
I had an attorney send me bench books that are on there. I had jail staff print off owner's manuals for cameras, which was part of my defense, which is not allowed to be admitted at trial. There's video between me and my wife, all of our visits while I was in jail. That's not part of the lower court record. And also I should add that I have 4 children and there's custody proceedings pending. Mr. Fager's here. I don't know if you want to address him
All right,
first.
yes, let's take a break from the USB and Mr. Fagan, is it saying your name right, sir? Mr. Fagan?
Fager. With an R.
All right. Mr. Meyer has asked that I have you give brief testimony regarding the whereabouts of the CD or DVD that came from the Ogama Circuit Court. I'd like to have you do that. All right, Mr. Langschwager, do you want to make any preliminary objection before we do so?
No, Your Honor, but I think he should be sworn in.
Oh, of course. Yeah. All right. Very good. Mr. Fager, if you'd raise your right hand. You solemnly swear to, that in this proceeding you will testify fully and completely and only as to the truth.
I do.
All right. Mr. Meyer, you want to ask him a question or two?
Yes. Mr. Fager, just briefly, is it true that you still possess the CD or DVD that was sent from the 34th Circuit Court?
Yes, I do.
Okay, and that's all.
All right, and Mr. Fager, where is that maintained?
It's in my files, locked in my litigation files for the rest of the facility.
Thank you. And what is your position with the department?
I'm the warden's administrative assistant and also the litigation coordinator at Ernest C. Brooks.
Thank you, sir. Mr. Langsberger, any questions?
Yes, a quick question is, how would you like to, have you made a decision on disposing of the CD yet, DVD?
We're waiting for these proceedings to be completed before we proceed with that.
So you're waiting for, are you waiting for the court to decide on the CD/DVD, or are you waiting for the prisoner to give you instruction as to what he wants
Both.
done? So
Both.
that, is it your understanding that the prisoner has not given you an instruction as to how he wants the item either disposed of or sent to an outside person?
That is correct.
Thank you.
Mr. Fager, my understanding is that well, first of all, is it a CD or a DVD, if you know?
As far as I know, it's a CD.
All right. And my understanding from correspondence that's in the file is that this came directly from the circuit court. Is that correct? To your
I
understanding?
cannot answer to that, but I believe that's true, yes.
Okay. I think I don't have any other questions for you, sir. Thank you very much. Any other questions, Mr. Meyer, Mr. Langsberger, for this witness?
No,
Your Honor.
All right, very good. Thank you, Mr. Fager. You can.
Yes, sir.
All right, well, while we're talking about the CD, I have some questions for you, Mr. Meyer. What is on that CD? I reviewed the record, and it looks to me like the court sent you that you have the transcript, and the court sent you all the paper exhibits, copies of the photographs, and so on. What is on that CD that you don't already have that is relevant to your pending appeal?
video exhibits that were introduced at trial. There's some expert animated maps for my cell phone location that was given to me on the 5th day of trial as discovery. It was new discovery.
Well, when it's given to you, my question is, was that entered into evidence in the course of your trial?
Yes, and that's what's on the CD is they're exhibits from trial.
I understand, but it seems to me that as far as any paper exhibit, you clearly have an alternative mechanism to receive those materials if you have not already done so. So that's why I'm trying to hone in on this video exhibit. I'm not sure what it is. Is this a film of the is this the dash cam of the stop?
There's multiple videos on there. It wasn't just one exhibit. There's some of it was my interview. It's a short clip of my interview, I think was introduced as an exhibit. There's some dash cam footage as well that was introduced. It's just a short clip, I think 1.5 minutes of probably 12 hours worth of dash cam footage. Another exhibit would be an animated map, which is a video. There's a PowerPoint presentation.
Was that
What's that?
Was that something that was introduced by the prosecution's expert?
Yes, the cell tower expert. And specifically those videos I don't have a copy of, and it was new evidence. To this day, I have not been able to consult with my expert in Indiana, and he hasn't been able to look at that stuff because I don't have access to it.
Okay.
And as far as any other, I mean, there's multiple exhibits on there. There's dispatch, audio dispatch, which is going to be relevant for my motion for new trial, which was adjourned, by the way. That was adjourned from January 17th, and it's now scheduled for February 7th.
And am I correct that the relevancy of these materials is based upon your argument that there was some defect in the stop, and that therefore that would have led to exclusion of evidence of your guilt?
Yes, sir.
And how would that have been?
Well, okay, so if we're talking
stop, Mr. Meyer, let's assume it was a bad stop.
Right.
What evidence was discovered in the course of that stop that you claim should have been suppressed?
What evidence? Well, the money from the robbery, my DNA, which was made pursuant to a search warrant after the fact. There was a cell phone that was seized from me, and then there was a subsequent searching of that. for my cell phone records. All of that should have been suppressed. I was actually, the seizure occurred when they used force during the stop. It wasn't
Yes,
necessarily this, it wasn't the stop itself. It was the use of force during the stop, which amounted to a seizure.
Okay. Mr. Langford, do you have any questions for Mr. Meyer regarding the materials on the CD?
So Your Honor, I am not here to try his criminal case or his criminal appeal. So in this case, I would say that something like that, it's better outside of the institution where he's going to have somebody that's able to keep it safe. He has a brother that he's in contact with that has emailed me on other litigation. I think that's where it belongs.
Sure. And I'm hold on, Mr. Meyer. I'm very sympathetic to your position, to the defense position. My only concerns, if I question the relevancy of these items, but nevertheless, if they were admitted at trial and they're only available on video, it seems to me that under the court rule, he has a right to have some access to them, at least an opportunity to view them as he prepares an appellate brief. Do you have any response to that?
Once again, this is not part of his criminal proceedings. I'm not here to represent the prosecutor's office. In this case, we're really getting in and blurring some lines. I do think that he is better off having his brother assist him with material outside, because now we're going to get into things. How much computer time does he get? Do we have a computer that can access this information? Is the department going to have to somehow provide him with a means to duplicate certain things? It's going to go on. And somebody on the outside is in a better position to help him out with production of material than where he's at right now.
All right, very good.
Your Honor, if I may?
Yeah, sure, go ahead.
I understand that argument, but that argument is actually unconstitutional, because what that would be asking, right? Let's think about the logistics of that. If somebody outside of the prison, first of all, this case isn't just about me and my rights. This is about protecting rights of all the prisoners. There needs to be a change.
Let's focus on you.
And let's focus on me and focus on the logistics of, let's say we send that to my brother, right? Then what happens? He gets the thumb drive, and he, just as Mr. Langschwager pointed out, we have to think about duplicating that. That means my brother would have to go to the store and spend his own money on another thumb drive, right, to make a duplication. So what you're asking my brother to do is to subsidize my speech, which is unconstitutional. You would be unconstitutionally compelling my brother to pay for my litigation, which is not his financial responsibility. And then on top of that, it's not as simple as send him the thumb drive and let him have his way with it. I would have to communicate with my brother. Now, phone calls aren't free. So I would have to call him, and I'd get a 15-minute phone call that he would have to pay for, right? And then after he pays for it, then he has to go on the thumb drive, and then I have to wait 15 minutes and then call him back. And then I have to fight with all the gangs in here who are running the phones to try and do that. So logistically, it's almost impossible what you're asking me to do. And you're asking my brother to pay for it and foot the bill, which is unconstitutional.
All right, thank you very much. Let's move on to the USB. Now, these are not materials that were entered into evidence at trial, or certainly not materials that are not available elsewhere. And it's clear to me that the USB did not come to you, Mr. Meyer, through proper channels. Do you dispute that?
I do dispute that, actually, and I have witnesses who can attest to it. Your Honor, I filed a response to the defense's summary disposition motion, and I filed an affidavit with that response, and I filed a brief in support of my response that I swore to all the facts in there. Okay, I was transported from Ogama, and I'm actually under oath right now. I was transported from Ogama County by Sergeant Tom Howard and a deputy who I named in my brief to Jackson Quarantine, when I was committed to prison. and they had possession of the USB, which is now under review. Okay. And they gave that over. They kept the chain of evidence never transferred to me until I got to the MDOC. They maintained custody. They gave that custody to MDOC staff. They were present while I was strip searched. They can testify to this. They can attest to this. Okay. MDOC staff gave me this thumb drive while I was in quarantine. After I got processed, they went through my legal stuff and he gave me the thumb drive. And yes, I hid it. I understand that's an issue. I understand that there's a problem with that, but I hid it for a reason. And I said that in my response to the ALJ on the misconduct. I said the reason I hid that wasn't because I was smuggling it. I hid it because I knew that I would have to go through all of this that I'm going through right now, right? Because the MDOC isn't allowing people to do these things. And then after going through 2 attorneys who refused to communicate with me about my criminal case, and then it was the USB was discovered, right? That's when I decided I needed to represent myself to get this USB back. And that's what I'm trying to do now.
Unfortunately, it would have been far better if you had an attorney at this point, because all of this would be moot. The attorney would have access to all of this, but that ship has sailed.
But I have a constitutional right to represent myself as well.
Don't deny it. Don't deny it.
And Your Honor,
just letting you know that when you're in prison, if you don't have an attorney, this is how everything becomes way, way more difficult in terms of preparing your appeal. But that's an editorial comment which you can ignore.
I understand that. I get your belief, but here's the thing. I have been trying to file an appeal of this misconduct since June. I filed it 5 different times. It was filed within the 60-day limitation. And here's the thing, Your Honor, I'm asking to amend my complaint to add review of the misconduct. The misconduct, the only way I can appeal it is to, make it a part of this complaint, because it would be under 2.203, it would be a compulsory joinder of claim.
Mr. Meyer, I'm not going to let you amend your complaint again. You brought this matter to the attention of the Court of Appeals. You brought this matter to the attention of the Ogama Circuit Court. And that's enough. This is you filed tons of motions, and your requests, while perhaps reasonable, are also unusual. And at some point, I have to make a ruling. Okay.
I understand that. Your Honor, and I understand. Can I just make an argument about the res judicata? Because I understand that that's what you're implying when you talk about.
I'm not saying it's res judicata. Res judicata would mean it's final and can't be reviewed again. I'm just indicating that this has gone through multiple decision makers already. All right. Now let's talk for a moment about. Hold on, Mr. Meyer. Now, defense counsel presented a brief, which I imagine you've seen, reviewing the.
I got it an hour ago.
Okay, well, I'll go through them for you. The 4 factors regarding injunctive relief. And one is whether you have an alternative adequate remedy. And in part, the remedy was the access to the circuit court and the Court of Appeals, although you didn't prevail in either place. So, and of course, and your brother can have access to these items. So why, in your view, do you not have an adequate remedy?
Because a mandamus in the Court of Appeals is an extreme remedy that will only issue when there is not another available remedy. So the mandamus should have never been filed in the Court of Appeals. I would have never won, because the other available remedy is this replevin action or judicial review of the misconduct, which I filed 5 times. 5 times I filed, and it keeps getting rejected by the clerks. The clerks, not the court, the clerks. And as far as my brother goes, I told you, I refuse to force him to subsidize my speech. How would he send me a digital exhibit for me to attach to my brief
Mr. Meyer,
on appeal?
I got to tell you, I'm very unimpressed with the fact that you saying your brother can't afford a thumb drive. All right. It carries very, very little weight. You may think it's a constitutional right, and that's perfectly fine. But in terms of balancing these factors, The fact that your brother would have to receive something in the mail and make a copy doesn't move me at all. All right? So now let's talk about for a moment for the irreparable injury, which is another factor. And your argument is the injury is, as I understand it, the injury would be irreparable because these items are necessary for you to prevail on appeal.
I won't have use of my property. Plus I have litigation going on with the custody of my children, which I would like to be able to have access to the communications with my ex-wife and my other children's mothers, which are on that USB drive.
And why is it, other than the cost involved, why can't your brother receive these items and either provide you with a summary of them or a transcript of them or an explanation about what's on them?
Well, a transcript would cost money. So there's one reason. If my brother were to make a digital copy, he couldn't send it to me to attach to a motion or a brief. So how can he can't file something on my behalf.
Okay.
You're asking him to represent me. He can't do that.
All right. I think I understand the issues of the public interest and the likelihood of prevailing on the merits. Mr. Langschreiber, do you want to say anything else about the USB?
Like I said before, and it should go to his brother. His brother can assist him. In fact, these reference that he has an expert that he hasn't been able to give items to. His brother can send those items to that expert too. The fact that he hasn't availed himself of counsel at this point, and I understand it's a constitutional right. I agree with the court that it is not a very good decision.
Okay. Mr. Meyer, what else do you want to tell me? Anything else?
Yeah, I'm sure I do, actually. So I'm a little confused. So you're granting the motion to dismiss based on a failure to exhaust.
Right.
But the misconduct was exhausted. I asked for a rehearing. Now I'm asking for judicial review of the misconduct.
Mr. Meyer, I'm not hearing argument on the summary disposition motion now. Hearing argument on the specific matter of this USB and arguably the CD as well, although it's not clear to me that my order actually encompasses it.
Okay, well, I guess
I'll give you my personal view that the requirements of preservation are onerous and arguably arbitrary. Nevertheless, they're the legal requirements, and I have to enforce them.
Okay.
All right.
Okay, but okay, so my argument would be this, though, that because I still can file a judicial review of the misconduct, there should still continue an injunction until that claim has been adjudicated.
Okay. I'm a little confused. What misconduct are you talking about now?
On the USB, that the misconduct that was issued for the USB. Because I was denied due process there, that the ALJ's decision was not based on substantial evidence. So I could prevail on the misconduct, but if this court denies further injunction, then the USB will be destroyed.
I understand.
I'm not sending it to my brother.
Okay. I've heard all I need to hear. I think, Mr. Langtroy, anything else you want to say? And then I'll give you an indication what we're doing.
No, Your Honor, I think it's clear that this has to have some kind of parameter to it, that it can't be in kind of a snowball effect where everything gets blended into it. And I think that's where we're at right now.
All right. And let me ask you, Mr. Langtroy, can you, never mind. All right. So here's what I'm going to do. I'm going to direct that the Department of Corrections maintain these items till I issue an opinion, which I expect to have done within the next 14 days. But I'll just say, let's say for 28 days or until. I'm sorry. I'm a little want to make it clear. To retain possession of them and maintain them until such time as further order of the court. I anticipate that order will be coming in the next 14 days. I also am reconsidering my opinion in order insofar as I directed that Mr. Meyer, that you be permitted to file an action for declaratory judgment. I want to review the substance and see if in fact there is an underlying controversy that justifies pursuit of a declaratory judgment, and I'll review that in the opinion as well. So for now, you should hold off from filing any more amended complaints. The deadline of February 5th is also on hold because I'm determining whether or not you'll be permitted to file that amendment, and if so, I'll set a new date. Is that understood? Does that make sense? Do you understand what I'm ordering, Mr. Meyer? So I'm maintaining the status quo in all respects right now as to any amendments, and as to the items in question, the USB and the CD, DVD, till the court issues a further order, which I anticipate in the next 2 weeks, most certainly within the next 28 days.
Okay,
So
so
you're telling me don't amend my complaint?
Right, do not file an amended complaint at this time. And you know that your Court of Appeals complaint is not due until 42 days after the completion of your motion for new trial. So that's not a pressing deadline at this moment. Do you know when was your hearing adjourned to?
February 7th.
Well, we'll have something to you before then. All right.
Well, Your Honor, there is one more thing too, because I filed what's that?
I said, go ahead, but that'll be the last thing.
Okay, I filed a notice of transfer, file 23-00534 AA in the 30th Circuit to this court.
I thought the 30th Circuit had completed its work.
No, this is a different issue. This is a different issue, and it actually involves claim 2 and the money that was taken from my account, because Mr. Langschwager's position and the Attorney General's position is that the MDOC has a right under those orders to take those monies, but I have another legal theory that they don't have a right to take that money. The statute for which some orders operate under do not give the Department of Corrections authority to take money from the public that's deposited into prisoners' accounts. It's only money that prisoners make while they're on work assignment.
It's certainly an interesting argument. And
Yeah.
if that case is removed to the Court of Claims, then most likely my successor on the Court of Claims, because I'm leaving it shortly, will address that matter and determine whether or not it's properly before it, and if so, it'll proceed to handle the matter. Okay.
Your Honor, if I may address that briefly, that removal request is only for defendants. He is not a defendant, so he cannot have the case removed to the Court of Claims.
Well, you know more about it than me. I'm sorry to say. I've only seen a couple of those. I'll certainly take a look at that. If I'm sure that if it is a removal is filed by someone who's not entitled to a removal, that either the circuit court will not do so, or when it gets to the Court of Claims, the clerk's office will note that it's improperly before the court and send it back.
All right, one more thing as to
This,
the court's orders today. I would request, following the 28 days, if retention of these items is ordered, we would ask for a stay. And so I would like you to also rule on a stay request at that time too.
If I order any retention beyond the next order,
Beyond this 28 days.
then what I've said is that the stay will be in effect until I issue an order following this hearing, dealing with the matters that arose at this hearing. I imagine it within 28 days, but the deadline is my opinion in order, not 28 days.
All right, and we would ask if you do order a retention for the department, that we would ask for a stay on that so that we could preserve it for the next.
Sure, I'll be happy to do so. I'll be happy to do that. Okay. All right, Mr. Meyer, I'm going to give you the last word, and then we're done. Anything you want to say about he's requested a stay. That basically means that if I say they have to hold on to the stuff and let you have it, that would be stayed until the Court of Appeals reviewed it. That'll be something that I'll decide if and when I have to.
well, it sounds like you're dismissing it anyway, so I think a stay would be appropriate. I mean, if you're dismissing this, then I'm going to have to file an appeal.
Well, if I'm dismissing it, first of all, I haven't made a decision on that, but if I were to, no, I dismissed, what I dismissed was the guitar strings, and the deduction of the funds. I said the only
Okay.
thing left in my book is the question of the status of the USB and the CD.
Okay, see, I thought you were dismissing all four. I'm sorry.
Okay, no, that's okay. It's been
I misunderstood you.
And also, if in the end I rule against you, you of course may file an appeal as a civil action. But we don't stay. In other words, if I issue an order that says, you send it to his brother or you send it wherever you want, that's not something that I would stay. I'd be giving them direction to address it, because if I'm giving them relief, then they're entitled to act upon that relief until such time as I tell them otherwise. Okay?
Yeah, I get it.
Okay, very good. Thank you both very much. The matter is concluded, and that ends the hearing. Thank you very much.
Thank you, Your Honor.